Good morning, everyone. I hope you're doing well. I hope you're managing to get some exercise, although social distancing at the same time. It's been a difficult week. This has probably been the hardest week so far. As you can see, I'm in my office. It's Thursday before a long weekend, although who's counting that sort of thing anymore? Okay, anyway, today we're going to talk about the Federal Court of Canada. Okay, and we're going to do this. We're going to talk a little bit about a little bit about its history. We're going to talk a little bit about the rules of the court itself. We're going to see that there's many similarities, of course, with the Ontario rules of civil procedure. And then we'll just sort of go through the questions that we had as well. So really, all you need in front of you is the document that I sent you and posted on Blackboard for you to review. And then from there, we will learn about it. But as we're getting closer to the exam, I will post more about that today, in fact. But just so you know, there's not a whole lot on the federal court on the exam, simply because it is sort of not what we've covered through most of the course. So again, let's get right into it. So we will start with, as we do in many cases, with a little talk of the Constitution of Canada. And as you know, I love it, a little constitutional history. And of course, a little constitutional present. So we have a federal court, and you know that most of the work that we have done this semester has dealt with the provincial courts in Ontario. So we have the Ontario Rules of Civil Procedure and the Small Claims Rules. And those are created by statute and orders in council by the Legislature of Ontario, or orders and councils by the Attorney General of the Province of Ontario. So for the most part, the day-to-day operations of the courts in which we live in are operated at a provincial level. And that's the same, of course, across Canada. So the BC courts, in the BC legislature and government there, will deal with the BC courts and so on as we move east. But of course, Canada has a significant role to play in our daily lives as well. And problems that arise within the framework of Canada are dealt with in the federal courts. And so there is a federal court that sits in Toronto. It's actually just across University Avenue on Queen Street, right across from Osgoode Hall, where the Court of Appeal of Ontario sits. And there's also, of course, a federal court in Ottawa. But I think those are the only two spots in the province of Ontario where the federal court sits. And it doesn't have as many courthouses, I think, but I could be wrong, but I think it sits in the capitals of the provinces across Canada, possibly one in Montreal, but I don't know, but that would make sense. So anyway, that's sort of how it works. But how do we get the Federal Court of Canada generally? So I'm going to open up the Federal Court. Let me just find it here. Okay, I've just opened up the document that we were looking at and looked at the history of the Federal Court of Canada. So the history of the Federal Court comes to us from 1971. So it's not a whole lot older than I am. But what it is it's the heir of the Exchequer Court of Canada, which goes back much further. So let's look at, of course, the Constitution Act of 1867, now what it was then the British North America Act, to get a sense of sort of how this all came about. So you'll recall that in the negotiations leading up to the creation of Canada and Dominion Day, Canada Day as it's now called, July 1st, 1867, it was pretty much a deal brokered between four provinces at the time. One was Nova Scotia, the other was New Brunswick, but by far the two biggest and most populated provinces at this time were called Canada East, which is now known as Quebec, and Canada West, which is now known as Ontario. Now, those two political units had been in a union of Canada since 1840, and this was sort of a way to expand Canada as it was to include all of the British North American colonies at the time. So Nova Scotia, New Brunswick, Prince Edward Island were there, and sort of very small maritime provinces. And so they actually had a meeting in Charlottetown, PEI, to unite into a maritime province, one maritime colony. And the party was crashed by the Upper Canadians, or the folks from Canada West, led by Sir John A. Macdonald, a lawyer from Kingston, Ontario. And they basically got the ball rolling, and there was some resistance in the maritime provinces to joining up with the bigger colonies in the St. Lawrence and the Great Lakes areas. But eventually we got Canada. And one of the issues that Sir John A. Macdonald had to deal with was the idea of Quebec, a French-speaking, largely Catholic population that had its own laws. And you'll recall from your intro to the Canadian legal system class, and I'm teaching that this semester, so that's probably why I'm talking about this a lot. But they had a civil law. They had the civil law that went back to France, and ultimately went back to Roman law, the Justinian Code, and so on and so forth. So they had a separate legal system. They had a separate educational system. They had a separate healthcare system. They had a separate faith, Catholicism, which had significant presence in both the educational system and in the healthcare delivery system as well. So Georges Etienne Cartier, a leader of the Canada Easters, or the Canadiens, or the Quebecers, we'll call them that, they insisted on a federal state, so two levels of government. And so Ontario runs the court system because we have, since the early 1790s, when we established our legal system in this province in Ontario, the area now known as Ontario, we've been a common law jurisdiction from there. Of course, the land where you're sitting on used to be part of Quebec. Quebec used to reach all the way down into, I think, St. Louis, Missouri. It went way down the Mississippi River. But this, of course, used to be Quebec too, and not far from me, where I am on King Street, there's an old French fort. There's nothing there except an outline made by concrete slabs, but you get the idea. So anyway, we had a federal level of government that dealt with big items, and this was enumerated in Section 91 of the British North America Act, now the Constitution Act 1867, and that sort of, it would deal with coinage, it would deal with measurements, it would deal with military and foreign affairs, it would coinage currency, whereas the provincial governments, they would deal with education, healthcare delivery, and the justice system, the delivery of the justice system. But Canada's too big not to have a place to settle federal disputes. And so when the Supreme Court of Canada was created in 1875, so was an Exchequer Court of Canada. And so an Exchequer Court, what is an Exchequer Court? Oxford Legal Dictionary, let me read it to you right now. So Exchequer, the department within government that receives and controls the national revenue. C, Chancellor of the Exchequer, Chancellor of the Exchequer, or Court of Exchequer. So the Minister of Finance in the United Kingdom to this day is called the Chancellor of the Exchequer. And that individual is responsible for, as the Minister of Finance in Ottawa, or the Minister of Finance in the province of Ontario here in Toronto, is responsible for dealing with the finances of the jurisdiction to which they're controlled. Chancellor of the Exchequer, just so you know, is given a house as well over in the UK. You know how the Prime Minister of the UK lives at number 10 Downing Street? Well, the Chancellor of the Exchequer in the UK lives at number 11 Downing Street. And so they're neighbors, and it's a very important role. And many of you know us, I had the honor of working for the Minister of Finance at one point in my career, many years ago now, of course. The minister there was not given a house like the Prime Minister of Canada is, but it is still a very important job, one of the most important jobs in the federal government. And likewise, the Minister of Finance in the province of Ontario, very important job as well, will be as this COVID-19 state of emergency continues. So it's 1875. We have an Exchequer Court of Canada. And the Exchequer Court of Canada would deal with, well, let's have a look here. And it was, of course, it was created under the statutory authority of Section 101, which authorized, of the British North America Act 1867, which authorized Parliament to create, quote, a General Court of Appeal for Canada, a Supreme Court, and additional courts for the better administration of the laws of Canada. Accordingly, the Parliament passed legislation in 1876 creating the Supreme Court of Canada and the Exchequer Court of Canada. Now, we know that for the longest time after the creation of the Supreme Court of Canada, that it wasn't the court of last resort. It was not the apex court at the top of the tip of our judicial system here in Canada until 1949, when civil appeals to the Judicial Committee of the Privy Council in London were ended. Of course, up until 1931, basically all appeals could be appealed over to the United Kingdom. But the Statute of Westminster, which allowed Canada to legislate on its own without any interference from the United Kingdom, was passed over in the United Kingdom in 1931. That, of course, led to the Parliament of Canada ending all criminal appeals in 1931 or 32, ending all criminal appeals to the Judicial Committee Privy Council of the Privy Council in Westminster. And then from there, it was just a question of time before sort of the older ways would give way to the new ways. And so we had an Exchequer Court. Post-World War II, we have also the rise of the administrative state. So the executive branch and the Parliament start seeing that there is wisdom, and of course we can assess whether this was a wise decision or not. I'm not going to go there. But there was, what was happening is that administrative tribunals were starting to spring up. So as the state became more pervasive in the lives of Canadians, then what the statutes would do is create a tribunal, and that tribunal would adjudicate minor issues, and then if required, the court would be called upon to judicially review those tribunals if they needed to do that, if there was an egregious decision or something along those lines. So again, not going into there. What I'm only doing is setting up that the Exchequer Court in 1971 saw its mandate slightly changed to account for these larger changes in Canadian society. One of those was, let's get a better, more accurate name. So the Exchequer name was changed from the Exchequer Court to the Federal Court, and it also acquired powers of judicial review. So it was start to review tribunal decisions as well. And then somewhere along the line, and I'm not exactly sure where, but it acquired the powers of admiralty and maritime law. So all of a sudden, the former admiralty courts, and I'm going to pause right now just to check. Okay, I'm back, and I can't believe I didn't know this off the top of my head, and I have acquired some other viewers or friends, law school friends watching my videos now, so they're probably going to make fun of me because of this, because I'm sort of, but one of my other passions is maritime law. It's Toronto. I don't practice it a lot, but which is to say I don't practice it because it's just sort of not something that comes up in my practice. But anyway, so after the study, we've talked about the criminal, the end of criminal appeals to the Judicial Committee. Well, in 1931, the Statute of Westminster. Shortly thereafter, in 1934, the Admiralty Act. The Canadian courts, the Exchequer Court, eventually the Federal Court, acquired all the powers to deal with the High Court of Justice in England when it came to admiralty and maritime law. So whenever there is a legal dispute on the high seas, and that does include, for the purposes of this, the Great Lakes. The Great Lakes are a maritime jurisdiction, as you saw in the questions. then the federal court of Canada is what deals with that. So there you go. That's sort of the background and the status of where the federal court of Canada is. So let's now turn our attention back to the document, and we'll look at the jurisdiction. Just if you want to, the jurisdictions on the website are of the federal court is quite good, so we'll just sort of go through there. Federal subject matter. Unlike the superior courts established by the provinces, the federal court does not have inherent general jurisdiction. In order for the federal court to have authority to hear a given subject matter, the subject must be assigned to it by Parliament under the Constitution. There must be actual existing applicable federal law, and the administration of the law of that law must have been conferred upon by the federal court. Okay, let's unpack that a little bit just to make it a little easier. So the superior court. So what is an inherent general jurisdiction? What is that? Okay, well, the superior court, as we call it, is sort of it is the successor of the high courts of Ontario and the high courts of England and Wales. And what it means to have an inherent general jurisdiction is that it has these court powers that predate sort of the modern times, right? So they go back to the Middle Ages. They have what's called inherent jurisdiction. They have been there so long that they derive a certain level of respect and understanding, not their people, not with regard to the law. The people there are no different than any other people, except they're highly qualified judges, et cetera, et cetera. But it is a court that goes back to largely the Middle Ages. And so it predates all of this, what we have now. So what it's basically saying there is that if I want to sue you for $100,000, and it's just sort of a tort case or it's a contract case, and there's not sort of some special area that has been, or jurisdiction or form that has been created by statute to take that specific case, I'm going to the superior court. I'm going to the heir of the high court of the medieval England, and Wales. So that's where I'm going. So what the federal court is that basically its powers and responsibilities to hear things have been carved out by federal statute. They have been created by the federal parliament. So for the federal court to have authority to hear a given subject matter, the subject must be assigned to Parliament under the Constitution. So number one, it has to be assigned to the federal Parliament. When you hear Parliament, you think of the federal Parliament, the beautiful building up in Ottawa. You don't think of the provincial legislature. And it's been assigned by the Constitution. So maritime law, for example, maritime disputes and maritime responsibilities have been assigned to the federal government. That's why it's Air Canada. That's why WestJet flies all over Canada. It's based in Alberta, WestJet is, but it is a federally regulated company in a federally regulated industry. Air Canada, based corporate headquarters in Montreal, but its biggest center, of course, is here in Toronto, and it's a national company like that. So it's assigned under the Constitution, to Parliament under the Constitution. There must be an applicable federal law, so they've created a law that is going to deal with disputes at the federal court level, and the administration of the law must have been conferred upon the federal court, and so it's basically the federal court's jurisdiction. So it's not inherent jurisdiction. You just don't go there for any old dispute. You have to go to the federal court of Canada when the statutes in the Constitution tell you you have to go there. Okay, so just look at the little buttons. We're not going to touch those, but administrative law. So when you're dealing with a federal administrative tribunal, Aboriginal law, that has been assigned, of course, in Section 91 and elsewhere in the Constitution. Maritime and Admiralty law. Intellectual property, that is a federal jurisdiction. National security, of course, the militia and the naval forces of Canada is specifically outlined in Section 91 of the Constitution. And citizenship, immigration, and refugee law. And so many of you, I know, or immigrants from other countries. You're not, for the most part, when it comes to the immigration, dealing with Ontario governments. Yes, in some place you are, but you are for the most part dealing with federal law when it comes to immigration, as you know. So that's it. Let's move on to our next form here. And so the rules of the court. Okay, so let's look at the rules of the court. And we don't have time, obviously, to go through every single rule of the court. That is not a wise use of our time. So what we're going to do is we're just going to go through just the broad overviews, and we're going to sort of look at some of the things that I've outlined in our study notes. So the rules look pretty, how to bring an application. Application, this part, general, exceptions, So part 5, let's just look at part 5. Section 300, how do we bring an application? Just as an example, no other reason except, we're just looking at application. So you know what an application is, of course. You know how it differs from an action. So look at section 300, which is located at part 5. Just have it open in front of you. 300A, applications for judicial review of administrative action, including applications under section 18(1) or 28 of the Act, unless the court blah, blah, blah. Proceedings required or permitted by or under an Act of Parliament to be brought by application, motion, originating notice of motion, so on. Let's look at these statutes. Section 33(1), Maritime Liability Act. So there is a maritime issue under the Constitution, Section 91 of the Constitution. Subrules C, Citizenship Act. D, Trademarks Act. F, Commercial Arbitration Code. So code meaning commercial arbitration at a federal level. Probably analogous to the Labor Code, which is the federal labor statute for Canada. The Divorce Act, because we know the solemnization of divorces is a federal responsibility according to Section 91 of the Constitution Act 1867. So that just sort of outlines some of the things for judicial review that they will do. Let's have a look. Keep going. Oh, this is stuff you'll know so well. Part 6, appeals, interpretation, commencement of appeal, appeal books, what to include. Let's look at that because I know you're experts in that sort of thing. Agreement appeal book. Within 30 days after filing the notice of appeal, sounds familiar, the parties shall agree in writing as to the documents, exhibits, and transcripts to be included in the appeal book and shall file a copy of that agreement. So you know by now exactly what that means. The parties are going to get together. We have our notice of appeal. The parties are going to get together, contact each other, and agree on sort of what is the relevant exhibits, what are the important transcripts to be included, and so on and so forth. So again, just you will find your way if you find yourself doing a lot of federal court work. And again, I don't know if you will or not, but you will find yourself getting to know these rules really well. Part 7, motions. Why do we skip over the early parts here? Well, that's because, so part 1, of course, application and interpretation. Part 2, the administration of the court, how the court works. Fees. Let's have a look at the fees. So fees are set out in Tariff A. And let's go down and look at Tariff A. Under section, first one I'm looking at, a statement of claim. So we're 1(1)A, I. Under section 48 of the Federal Courts Act, $2. That's a pretty good deal. Simplified, in a simplified action or in an appeal that proceeds by way of an action, $50. In any other action, $150. Fees are a little bit less expensive at the federal court than they are in the provincial superior court. But anyway, you get the ideas, right? So these are the rules of the court, and they're all available online Obviously, they're not in your annual practice, but you can find them online. And they're not in your annual practice, so it's not going to feature too large on the exam. So we've looked at the rules. Let's look at the role of the proto-notary of the Federal Court of Canada. So for that, I found a letter from the Canadian Bar Association, and I'm just going to open that now and just sort of give you a sense of that. So I found this. I thought it to be a very okay. So it's an old letter from 2015 addressed to then Minister of Justice and Attorney General of Canada, Peter MacKay, but it just sort of speaks to the roles. So let's go to paragraph 2. Proto-notaries are judicial officers of the federal court. The office was created in 1971 to advance, quote, the efficient performance of the work of the court. The role and responsibilities of proto-notaries have grown dramatically since, particularly after the 1998 amendments to the rules. Proto-notaries have a unique, important role that is integral to the proper functioning of the federal court. They have jurisdiction and discretion to make decisions on certain matters, very important, lightening the load of the judges, and they exercise case management functions. Hey, where have we seen that before? Case management, analogous to that of masters to help streamline cases. Case management is a key factor in the effective and cost-efficient use of scarce judicial resources. They complement the rule of justice, and so on and so forth. So proto-notaries, what we're looking at here is basically the federal equivalent of a provincial master. So we look then, as we will also do, and this is, it's not entirely, out of the a little cough. Out of the ordinary, if we look at sort of what a proto-notary can do. So let's do that right now. I skipped the other link that has the nominations. It sort of gives a little bit about there. So appeal of proto-notaries. Appeal, okay, this is an appeal of a proto-notary. And so let me just pause here and I'll find... Okay, I'm back, and I'm sorry about that, but the Federal Courts Act is the statute, which is the enabling statute of the rules of the federal court. But that is the where you find the proto-notary's responsibilities. So the Federal Court Act. So the governor and council, which is the cabinet and the executive branch, may appoint as proto-notaries of the federal court any fit and proper persons who are barristers or advocates in a province and who are, in the opinion of the governor and council, necessary for the efficient performance. So the powers and duties shall be determined by the rules, okay? And that is sort of where you would, again, find the rules. So, okay, so when you're dealing with sort of the powers of the proto-notaries, Part 3, rules applicable to all proceedings, and basically it's Section 50. A proto-notary may hear and make any necessary orders relating to any motion under these rules other than a motion, and it lists from A to L what they can. So they sort of have, a lot of responsibilities of which those are taken away from them, and they remain with the judges. So let's not go too deep into this. Let's just sort of move along here because we're kind of running out of time. But so if you need to appeal a proto-notary order, that is something to do. The jurisdiction of the federal court, and that is, I've just opened that link. So this is sort of the larger Federal Court Act, Section 22, and all the way down for who is what the federal court hears. So a lot of maritime jurisdiction of the Federal Court of Appeal, which again, very important. Let's just look at that section. So yeah, this is the Federal Court Act, Section 27, appeals from the federal court, and then the Federal Court of Appeal also hears appeals from the Tax Court of Canada. We're not going to talk about the Tax Court of Canada. It's not something I've had any contact with, but it's just not in the syllabus either. So just no jurisdiction of the Federal Court of Appeal. From the Federal Court of Appeal, of course, you go to the Supreme Court of Canada. And I've also included as the final note issues of national security, because we're living in a time where national security is very important, because we're all walking around with little, not only are they, I was thinking about my phone here, not only is it a Walkman and a VCR DVD player and a television and an alarm clock and a watch, etc., recording device, it's also a little tracker. And so national security issues, as I carry my phone and it emanates out into space, information about myself, it's that is becoming more important. So just something to consider for your own interests. Okay. So let's look at the questions here. And the questions will begin at